Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Hello, lovely people. It's the start of the new year for us here on BWTV. Good afternoon and welcome. We are starting off and going the full stretch between January and December 2026. And we are going to look at some of the very exciting, interesting, mind-boggling questions that you have when it comes to the law. And we're doing that courtesy BWF Solicitors, our trusted partners when it comes to the law. Now, this afternoon, we are going to look at skilled worker visas and some of the things that you need to know about them and the options you have when you want to switch to different visa routes. Loya Osma will be our guest and resource person from the fold of BWF Solicitors. My name is Oreku Frimpong. Good afternoon once again and welcome to the show. Let's get into it together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are live. Thank you very much for your time. And thank you very much for entering into the new year 2026 with us live on BWTV. I want to say thank you to BWF Solicitors for giving us the opportunity once again to come your way to educate you, enhance your knowledge, and also empower you to be able to look at what the law says, how you navigate around it, and also what to do in situations when you find some difficulty. My name is Oriku Frimpong. Good afternoon. Welcome to another edition of The Community and the Law. This afternoon, we're going to look at the care worker route and the options you have if you want to switch visa routes. And I mentioned earlier on, I want to reiterate, Lawyer Charles Osman will be a resource person and solicitor from BWF Solicitors to take us through this one. And we will also be looking at some updates that have come later part of the year 2025 into this new part of the year 2026, and also to get you to anticipate what is ahead of us in the months coming. That is January, February, March, April, May, June, July, up to December 2026. It's going to be a very wonderful year. So stick around and stay with us. Tell people we are live. We are live on Facebook and YouTube at BWF Solicitors and at BWTV UK. So when you join us, like the page, share the link, and also invite other people to come and enjoy what it is that we are bringing you this afternoon. Thank you once again. Those of you who have come on there, leave your comments in the comment section down below, either on Facebook or YouTube, and I'll be reading that and be welcoming you to the show as well. Once again, Happy New Year. Even though we've gone 10 days into the year, we still want to wish you a Happy New Year and urge you to stay with us throughout 2026. Now, let's see. I think there are some people who are actually expressing their appreciation and gratitude to BWF Solicitors for helping them through their immigration journeys and all the legal things we have. And we have one from a client who says that I'm extremely grateful for the excellent work carried out by BWF Solicitors, especially Mr. Bernard Usu and Emmanuel Ampao. Emmanuel Ampao is in our office in Accra. Now, the person continues to say that their professionalism, attention to detail, and clear guidance throughout the process made my spousal visa application successful. I was kept informed at every stage and everything was handled efficiently. I highly recommend their service. Yes, and I want to say without any equivocation that if you want a trusted legal partner in the UK, especially when it comes to family matters, when it comes to immigration issues, when it comes to business advice, when it comes to property and advice and all the rest of it, talk to BWF Solicitors. Call them on 0208 493 7340 0208 493 7340, or in emergency situations call 077 127 61884. Sorry, 077 127 61884, or visit their website www.bwfsolicitors.com, www.bwfsolicitors.com, or you visit any of the social media handles at BWF Solicitors. BWF Solicitors. BWF, thank you, thank you, thank you, thank you so much, and we will continue to say thank you. Now let's look at what we need to arm ourselves with in the week. We call it the nugget. Now, for our nugget, we're looking at Section 13(1)(a) and (b), Employment Rights Act of 1996. And what we're saying is, it is unlawful for an employer to make a deduction from wages of a worker unless A, the deduction is required or authorized to be made by virtue of a statutory provision or a relevant provision of a worker's contract, or the worker has previously signified in writing his agreement or consent to the making of the deduction. It is unlawful for an employer to make a deduction from wages of a worker employed by him unless the deduction is required or authorized to be made by virtue of a statutory provision or a relevant provision of a worker's contract, or the worker has previously signified in writing his agreement or consent to the making of the deduction. And as I said, I quoted this one from section 13(1)(a) and (b) of the Employment Right of 1996. Lawyer Asma will be detailing some of the things that we need to look at. If you pick up your payslip, you realize that taxes are deducted, national insurance is deducted. There are people sometimes have student loans, and those things are deducted. Are these the statutory ones? What else could be deducted? And if it has to be deducted, what needs to be done or signed for? Because these are things that are being taken away from your salary. Lawyer Asma, as I said, will be helping us do that. But even before he does that, let me pose a scenario and ask you a question so then you can think around it on the lines of this one. So Philippa works as a healthcare assistant at Care and Cure Limited. Her salary is £2,000 per calendar month after deductions. Such deductions include her income tax, national insurance, and pensions. In December 2025, she received a salary of 1,850. So she questioned the employer about the difference in salary, and she was told that there was a deduction of £150 towards 10 days unauthorized absence from work, and that the deduction was to pay for her cover. So Philippa wants advice. What are we going to say to Philippa? Are we going to say that as Philippa was absent without permission from work, the £150 deduction is fair to pay for the cost of her cover? Are we going to say, as Philippa has not agreed to the deduction with the employer, it's unlawful for the employer to do so? Or are we going to say, well, it's none of the previous pair of answers above because the deduction was a mistake and the refund will reflect in Philippa's January 2026 salary? Think about that. I know there will be some clues in Lawyer Asma's explanation, but in any case, I would want you to arm yourself with some of these bits of information so you will be so well empowered. So yeah, thank you, the person that expressed gratitude. Thank you for following us, and we've given you the nugget. And also thank you for staying with me whilst I'm giving this now. But think about that, because at the tail end of the program, I'll be coming back to it to ask for the correct answer. And then we'll put it to Lawyer Asma to find out whether we gave the right advice to Philippa. She was absent without permission from work, and £150 was deducted, and was to pay for the person who covered her duties. The Philippa also is saying that, well, she didn't agree to the deduction, so it is unlawful for the employer to really do so. And can we also say that, well, it's none of the above because it was a mistake. So it would be added back to her salary when they pay her in January 2026. Think about that. I'll be right back. And also make your presence felt in the comment section below, Facebook and YouTube at BWF Solicitors and at BWTV UK. It's the community and the law.
Case overview: a successful appeal at the upper tribunal. Our client, a national of Ghana, applied for an EEA family visa permit, relying on his marriage to a national of Germany. After a significant delay, the family permit was issued, and he arrived in the UK. A subsequent application under the EU settlement scheme was refused, and the appeal went to the upper tribunal. The challenge: proving that although our client's sponsor held a British passport in addition to her German passport, she was a relevant sponsor under EU settlement laws. The Home Office argued that as the sponsor was a British citizen, and although she was born in Ghana, she was a British citizen at birth. Therefore, her European citizenship did not confer any right on our client. Our strategy: proving that our client's sponsor did not automatically acquire British citizenship at birth, as the parents were not married. We gathered evidence that the sponsor's father was still married to his first wife in the UK before the sponsor was born. We relied on the 1948 British Nationality Act to challenge the Home Office assertion. In addition, we provided evidence going back 30 years to prove that the sponsor could not have been British at birth. A successful outcome. The upper tribunal allowed the appeal. They agreed with us that the sponsor was a relevant sponsor, and that she only acquired her German citizenship before acquiring her British citizenship. After 4 years of fighting the Home Office, our client can now stay with his wife lawfully in the UK. Key takeaways. Understanding that the only way to win a complex legal case is to painstakingly collate evidence, apply the evidence to the facts, and make the law relevant to your case. Ensuring that in appeals, the best way to win is to ensure the court bundle has the relevant evidence to support your skeleton argument. Always take legal advice where the facts are complex and require diligence and persistence. Facing complex immigration issues? Contact BWF Solicitors today.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, thank you for sticking around, and I'm so happy you're still here with us. Remember, along the line, I will be asking you to, or I will activate the lines for you to be able to join us. And if you have any question or concern, you can put it to Lawyer Asma, resource person and guest. And also, if you have any contribution, you would want to put that across. For instance, like our friend that gave us that testimonial to say that Uncle Ben and the staff really helped with the spousal visa application. We also had that testimonial from others who, for various reasons, have had to go through a lot of immigration challenges. But with BWF solicitors on the side, they were able to really surmount those challenges, and now they are successful and smiling. So if you want to have that experience as well, call BWF solicitors on 0208 493 7340, 0208 493 7340. And if you're in Ghana, the number is 0555 895959, 055 5895959. Emergency situations, call BWF Solicitors on 077 127 61884. 077 127 61884. What other routes do we have when it is that we are on the care worker route or the skilled worker route as we normally know it? And are there options? Why would you want to switch to another route? What are some of the reasons that would push you to switch to a different route? What are some of the challenges? If it is that you have to switch, what do you do? And when you have switched, what happens to yourself, your family members, your spouse, and all the rest of it? These are things that we will be looking at this afternoon on the program. So I would want you to just get yourselves ready as we will be getting into that discussion so very soon. Lovely family, Tilly Tuma is announcing herself. Thank you very much, Tilly. Thank you for doing that. And as I keep saying, when you join us online, either on Facebook or on YouTube, let us know that you are there and you put that in the comment section down below. Or you can send a text 07399208468. 07399208468. Adesafo is greeting everybody. Good afternoon to you there as well. Thank you for your time and thank you for sticking with us. Happy New Year. Nanaya, happy Saturday, everyone. Nanaya, thank you very much. Happy Saturday to you too. Tilly, please kindly share, comment, and like. Thank you. That's what Tilly is saying again. And appreciate that, Tilly. Thank you so very much. Nanajiman comes up and says share, share, and share. You know what? Let me announce this. In this year 2026, what we will be doing is one of the days or sometime along the line, we would have you, a few select of you, come into the studio, sit down with the lawyers. You will have the chance to be asking them the questions yourselves as I sit in the corner and coordinate. That would be that kind of open forum where we'll have you in the studio to help with the program. So get yourselves ready and keep your ears peeled. I will be doing that. Thank you for the education. This is so very helpful. Rose Usu Adichumwa sent in that one. Yeah, Rosie, as I said, keep your ears peeled. We might be selecting a few of you to come and join us live in the studio one of these days, so you have that interaction with the lawyers as well. Okay, at this point, I think I will be so right to bring in lawyer Charles Aswa, so we don't spend too much time on all the other bits. But not to say that my introduction and my welcome to all of you is not necessary. Keep them coming through. I love your comments and I want to read them. And of course, you make the algorithm look so very good. Last, good afternoon.
Good afternoon, Brakoku.
Afishapa.
I think I'm at you. This is not white.
Yeah. Well, I said Happy New Year to Akucha. So those of you probably who thought I was getting you lost, I'm not getting you lost. I'm just expressing my excitement for seeing him for the very first time in the year 2026. I believe you have had some rest and so refreshed to go the full haul in the year 2026. Akucha.
Yes, we are ready.
Yeah, I remember there's this game. I don't know whether you remember back in the day. Ready, ready, and say ever ready. So we are ever ready to go the long haul, and we appreciate. We've got so many people online waiting for us to start our discussion and the rest of it. I will start off with maybe for you to say good afternoon and happy new year to the our viewers, clients, and the rest of the people we deal with. But then I'll go after that to the nuggets that no employer has a right to deduct money from my salary if I do not agree to it. We'll come to that. So let me give you that opportunity to say your hellos. Then we pick up the nugget and you help us with it, Uncle Charles.
Thank you very much. Very good afternoon to viewers and listeners, and a happy new year to everybody. It's our hope and prayer that this year, whoever is seeking to regularize a stay or to ensure that their immigration dreams come true, it will happen for them.
Well, thank you very much. And as Oliver will be asking for more, so definitely we want to pray that you have good health and strength so that we can have you and your compatriots at BWF Solicitors with us every Saturday afternoon. So we can put our questions to you. You can also educate us as well. Then we start with this one. The nugget we had earlier in the week, Uncle Charles, said that it is unlawful for an employer to make a deduction from wages of a worker employed by them unless the deduction is required or authorized to be made by virtue of a statutory provision or a relevant provision of the worker's contract, or the worker has previously signified in writing a agreement or consent to making the deduction. Normally, lawyers, when you quote, we show the reference. And Uncle this is from Section 31A and B of the Employment Rights of 1996.
Section
So then
30,
I ask the
Section
question,
30,
and I know
Section
definitely
30.
viewers and contributors are also asking the question, what kind of deductions are statutory and what are not allowed?
Okay, so
Section
it's
13, yes, thank you.
Section 13.
Yeah.
Okay, right. Yes, so thank you very much. So within the Employment Right Act, we have seen that it is not lawful for an employer to deduct as and when they feel like deducting. And so any deduction must make lawful sense. And that one, it is required, and two, the employee has agreed. What is required are statutory deductions. What may be agreed may be things in-house that the employee might have agreed to. Anything else may not be acceptable. So once you sign up for the contract or employment under Section 1 of the Employment Right Act, Terms and Conditions of Employment, salary will be part of it. And salary will be specified. So X amount for the year. Once your month ends or prior to, the employer must deduct certain things from your salary for statutory reasons. One is tax. So tax is statutory under the tax provisions. That goes to HMRC. So that's called PAYE, pay as you earn, income tax. There's also national insurance. That is also deductible at source by the employer for government. There's also pension, what we call employee pension contribution. It's also deducted at source. Now, these are the statutory aspect or element. There may be instances where the employer will agree with the employee for certain things to be deducted, i.e., deduction for towards private pension, for example. So the employee has consented to that deduction. Deduction for uniform, for example. So the employer will provide all the uniform, then bit will be deducted as source. That is also with the consent of the employee. There may be other deductions where the employee has agreed that this should be taken from my salary for specific purpose on my behalf through a third party agent or a third party provider or manager. For example, health insurance could be deducted as source, or life insurance could be deducted as source. And that should be an agreement between the employer and the employee. Anything else outside the consent arrangement or the statutory arrangement is unlawful. And so, in as much as it is not agreed to by the employee or it is not provided by law that it has to be taken at source, the employer, after having taken that action to deduct, will be in breach of Section 13, subsection 1, subsection A and B of the Employment Right Act 1996. 26.
Then let me ask this quickly. You mentioned third parties. So, for instance, I owe somebody outside of work, and the person brings in a letter to say that this person owes me this much, and I have had this arrangement with the person for such an amount to be taken monthly from their wages so that they could repay me. Should that be part of the statutory requirement?
So there is something called enforcement. Enforcement is where somebody is required by court order to make payment, and the person is not paying. So they go to the employer to take the payment from there. That becomes lawful because for that enforcement, you know that there are some instances where they will say, okay, can you complete your earnings, where you work, how much you earn, and all that. They will make an earning assessment and take from source. That is allowed. Now we're also looking at, for example, child maintenance contribution or support. And the child maintenance department or service is taking this at source from your salary directly. That is also, but you can see that even if it is coming from child maintenance, it cannot be without your consent. You agree to it. Because child maintenance will say complete a form so that we take it from your employee, from your salary at source. So you've consented. And again, if it is court order where an enforcement has been placed against you for deduction from earnings, then again you have to consent to that or sign a paper. That is consent. So those third parties, obviously, it will still be with your consent or the employee's consent. You can't do without the employee being aware. So let's assume that the employee owes somebody a third party money, and the third party goes to the employer to say, can you take it from source for me? That will be unlawful because that will be without the consent of the employee.
So, for instance, if I have debt collectors following me, they go to my employer to say that such and such a person owes me this much. Would my employer have to consult me first before agreeing to their request?
So the debt collector is collecting from the employer. But remember, the agreement is between the debt collector and the employee, not the debt collector and the employer. So if the employer agrees to do anything on behalf of the debt collector or on behalf of the employee to the debt collector, then it cannot be without the permission or notice of the employee. You agree?
Okay.
And if the employee is with notice and has agreed to that, then that's consent.
Okay. All right. And then maybe you may not have to answer this question, but I have this scenario. I have this lady who was employed in a care company, and there was £2,000 agreed that after all deductions, she would receive that amount of money. Now, in December last year, Laura, she received her salary and it was less £150. The employer said that, well, you did not come to work at a certain point in time, and that 150 was used to pay for somebody who covered your duty. Does it fall under this one?
Is that a question to answer?
It's a question I've put to my viewers, but
right. So that's not a question to answer.
Would it fall under something like this?
Oh, so are you asking whether this question falls under the conversation we've had?
Yes, yeah.
Oh, right. Okay, it's clearer because you said that you were going to read something, but that is maybe not for me to answer.
Yeah.
That's why.
Don't give me the correct answer because I want to test them.
Oh, right. I get what you mean.
I want to find out.
Right. I get it. Okay, yeah. So I mean, So now, if somebody doesn't come to work, that is absence. It has nothing to do with the person's contractual compensation. And so if the person,
Leave it there. Leave it there for me because I know you want to avoid it, but you make it too easy for them. We'll come back to it.
we'll come back to
If you
that.
don't mind.
Sure.
Well, Asma is our resource person and guest from BWF Solicitors, who's going to help us discuss skilled worker visas, the options to look at when you switch to a different route. So get yourselves ready, and I would ask you to continue to keep your comments coming in the comment section down below, or send it to 07399 208468, and we'll pick them up to answer after the discussion and after this message.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello again, and welcome. I believe that you're so hyped up to get into that discussion, so I will not waste your time anymore. Let's get into it and ask lawyer Charles Asma, the skilled worker visas. Why would somebody want to switch to a different route when you say you're coming into the UK for X, Y, and Z? What are the conditions that will push somebody to do that? And when there's a need to do that, what options there are available for people to choose from, and the ramifications of those choices, and of course, how to make the right decision. Uncle Charles.
Thank you very much, Brakuku. So, viewers and listeners, today we are looking at switching from your current status as a skilled worker migrant or dependent of a skilled worker migrant to any other categories. And so the topic is clear. The topic says skilled worker visas, options to switch to other categories, or options to switch. To switch means that you have it and you are trading it in for something else. You have it and you are exchanging for something else. If you don't have it and you are going for something, then that is not a switch. That is a fresh application or regularization of stay. So a skilled worker who has can trade in for other categories or visas. The same applies to skilled worker migrant dependent can also ask for other categories, trade in for other categories. So we know that skilled workers enter the UK to work for specific employers.
Mhm.
Whilst working for the employer, they have a choice to migrate to other categories. And any other categories are any other category that is required by law. But of course, they have to meet the requirement under that category. It means that before the visa expires, they would have done that because that visa must be valid before they can trade it in with other visas. What will make a skilled worker wish to do that? Because there have been change in circumstance
Okay.
that now they wish to make another application. There's nothing wrong changing your mind. So somebody will enter the UK on a particular visa and will switch to other categories available. That is fine. Just like changing your mind. So there's no law that says that you cannot change your mind if you came on a particular visa. You cannot change your mind to do another application. If you're in the UK and your visa is still valid, you can. The only way you cannot will be, or any time you cannot, is when you are holding a visitor's visa and it hasn't expired. But for this conversation, it's a skilled worker dependent and skilled worker migrants themselves. So the visa is valid, it's exempt. Why will make what will make somebody want to switch? It's a matter of desire. So, for example, somebody might be in the UK as a skilled worker. They enter the UK, they have their parents in the UK.
Mhm.
They can apply to join or remain with their parents instead of continuing under their spouse or under that employer's contract with them. Parents will come to that threshold. What sort of parent are we looking at? So we have understood that under appendix skilled worker, you are able to switch to other categories. So you can switch to parent under appendix FM. You can switch to student under appendix student based on specific categories or specific conditions. You can switch to spouse under appendix FM. You can switch to private life under appendix private life. Of course, you have to meet the conditions.
Mhm.
So you can see that as a skilled worker, you can switch to other allowed categories.
Okay.
The main one will be appendix FM, appendix skilled worker again, transitioning to other skilled worker employment routes. So somebody can come in as a nurse and transition to teaching. Somebody can come in as a carer and transition to nurse or nursing, and so on and so forth. So here you are transferring from skilled worker employment visa to another skilled worker employment visa by different category or occupational code threshold.
Okay.
You can, as we said, move to family route. So family, once in the UK, you might have become a parent. Of course, there are conditions to that. So we'll come to the parent side. Or you have married or remarried and you are switching to remain with your new spouse or your spouse. That is under appendix FM. That's also allowed. Or you are transferring to appendix EU under appendix EU and EUSS visa categories based on a family member in the UK. That is, again, you must meet the requirement. So we're going to take them in turns and look at how the rules apply.
Okay.
Now, it doesn't really matter when you do it.
Okay.
All you need is you do it before the visa expires.
All right.
So,
If
yes,
you say you do it before the visa expires, so on the last day you can do it. or
As long as
you would have to wait, give yourself some room close to the expiration date?
the visa has not expired,
Mhm.
you can do it.
Okay.
Obviously, if you are going to do it and you can do it in minutes to expiry of the visa, hours, days, weeks, months, years.
Okay.
So it's really up to, but common sense will suggest to us that you do it in time.
Okay.
Yeah. As long as you do it, it doesn't matter when you did it, but you have to. So there are some instances where somebody will have to take time to make sure that they meet the rules and have all their evidence intact. Yes, that might mean that by the time the person has put all the evidence together, they are in their last hour or minute. This can still apply.
Okay. All right. So then you are going to pick them one after the other and take us through it. Let's start with it.
Right. So let's look at somebody who came in as a skilled worker migrant.
Mhm.
This person wants to transition from skilled worker migrant to another skilled worker migrant. That is one option. So you can switch from skilled worker migrant to another skilled worker migrant to or with another employer.
Okay.
You can switch to another employer, the same type of visa, or you can switch to another type of visa, different employer.
Okay.
So we're going to use one example. Somebody comes in as a carer
Mhm.
with code 6135, which is the current code. It used to be 61445. The person comes in, the person takes advantage of opportunities around and upskill, or the person had prior qualification and experience from abroad and they're able to find a job in teaching or in nursing or in childcare or in construction or in any other industry other than care industry. Once they qualify, they can transfer from care to that category or industry with different employer. That is allowed.
Okay.
So that is one option. So with that switch, you are switching within the same work visa spectrum. Work visa spectrum.
Okay.
So you can switch from work visa to another work visa before your current work visa expires.
Okay.
Or yeah, so even if the time the visa expires has been shortened by operation of law through the 60 days notice provisions,
Mhm.
it is still a new date and you have to operate within that new date. As long as you switch to another work visa, different employer, different employment category, different code category, you have switched. Of course, you have to meet the requirement. So that's one way of switching. You can also decide to forget about job or work and switch to anything completely different.
Mhm.
So if you look at switching within employment to a new employer, new industry, you can also switch to family. And with family, you are looking at you have become a father to a child. And here we have to look at who qualifies to be that child. The law says that for you to apply as a father or a mother under Appendix FM, so that you can transfer from skilled worker visa or a dependent of a skilled worker visa holder to another category as a parent of a child. The child must, one, be a British citizen child. Two, the child can be a child with indefinite leave to remain. Three, the child can be a child born in the UK and has lived in the UK for 5 years. Four, a child born abroad has been brought to the UK and has lived in the UK since the date of entry into the UK for 7 years. 5, a child who holds EU passport, another EU national child with indefinite or pre-settled status. So these are 5 categories of children that you can apply to remain in the UK with. And on that basis, you can apply as a parent, or I'll call it primary parent and secondary parent, and I will explain them.
Okay.
Primary parent is the biological parent. That is my definition of primary parent. That is not legal definition, my interpretation. So if you are coming in, I will ask you, are you coming as a primary parent or you are going in as a secondary parent? A primary parent, you are the biological parent. That means you must provide evidence of biological parentage.
Your birth certificate?
Birth certificate of that child, because you are a primary parent, what we call biological parent. And of course, if any of the 5 options we have mentioned that qualifies the child to sponsor you as a parent is present, you apply, you provide evidence. British passport if the child is British, or birth certificate to show that the child has lived in the UK since birth for 5 years, so that the child is a qualifying child, or date of entry into the UK. If the child was born abroad and since entering the UK has lived in the UK for 7 years, that is proof, and that they haven't left the UK. If it is EU child, EU passport plus 5 years pre-settled or settled status for that particular child. And that will show the immigration status for that child.
Okay.
Right. So, to be able to do this, apart from the work, any of the things we are mentioned from the family spectrum, you have to show that, 1, you have immigration status, because we said that you cannot switch if you don't have immigration status, because switch is a trading.
Okay.
So if you are trading in, then you must have status yourself to be able to exchange for another status. That's the switch. So you must have immigration status that is valid. 2, you must show relationship based on which you are making the application with that sponsor. 3, you must show English language. And English language, depending on whether you are applying as a spouse or as a parent, you may need English or not. So as a parent, you don't need English, but as a spouse, you will need English. But even as a parent, if you're applying under 5-year route or route, you will have to show English language. So the English language will come in there. So immigration status, relationship status, English language status, and finance or maintenance status. But as we pick them, we'll look at what specific requirements are needed for that particular bit. So as a parent, you can apply under 10-year route or under 5-year route. 5-year route means that you don't live with the mother and the child, but you play a role still in the life of that child. The law says...
If you could repeat that. You said the 5-year route means that you do not live with the mother of that child, but you play a role in the child's life. Is that a 5-year route?
So if you're applying under 5-year route, we'll check to see whether you are living with the family, the child and the mother, or you are just looking after your child, playing a role, having access to the child, but you have no business with the mother.
Okay.
If you have no business with the mother, then presumption is that you don't live with the mother.
Okay.
But you have direct access. Because if you are living with the mother and you apply, they will put you under 10-year route. I don't know why they put it like that, but it is what it is.
I was going to ask that question because my rationale for asking about not living with the mother was, this one is shorter. I don't live with a mother. I have played a direct role in the life of the child, yes. But if family values or family ties are to be kept properly well, I may have to be living with the mother. And then you give me 10 years for that. Why?
So this is the example. When you are applying under 5-year route, you have to meet all the categories, all the rules, the requirements.
Mm-hmm.
English is one and money is two.
Okay.
The maintenance requirement, financial requirement.
Mm-hmm.
So if you meet the maintenance requirement or the financial requirement, and you meet the English language, and you are applying based on the woman or the man, then you might as well apply under spouse, not parent.
Okay.
But you are choosing parent because there might be something missing that you don't have under spouse. For example, you may not have the money up to 29,000.
Okay.
And because you don't live it because so you may not have money up to 29,000, and the mother of the child, which is supposedly your partner, may not also have it, or you are able to have it, but the two of you have not lived together, or you have not been in a relationship for 2 years and you are not married.
Okay.
So if you are going under spouse and you don't meet the requirement for spouse, you have to then migrate to parent, because you may meet the requirement under parent. But under parent, if you are living with the mother of the child, the mother of the child, what we're saying to you is that, do you have the maintenance, the finance? Do you have the English language? Of course, all the other ones you have it. Are you married to the woman? For example, if you are not married to the woman, but you are living with her and the child as an married partner, and you haven't been for 2 years in that relationship, maybe the child was born 1 year ago, you've been in a relationship about 15 months. That's not up to 24 months. So you cannot say you've been in an unmarried relationship or partnership with the lady as to apply based on the lady.
Mm-hmm.
And so because the relationship with the partner is missing, you can only apply under the child as a parent.
Okay.
And if you are going to apply under the parent under the child as a parent, then they will tell you that because you all live together, you can only apply under 10-year route because certain things are not present. You don't meet all the requirements.
Oh, okay.
So that's the difference between 5-year route and 10-year route. So 5-year route is for people who meet all the requirements: English, finance, 29,000 gross.
Mm-hmm.
Then again, you have to show the immigration category and status and all that. So if you have it
Mm-hmm.
and you live with the mother and the child, then you have to apply as a spouse, not parent.
Not as a parent.
But some people may have good, I'll call it rapport, good rapport with their child, but not with the child's mother.
Okay.
So if you don't have good rapport with the child's mother, even if you live in the same household, there's no way the woman will sponsor your application. But the woman can attest to the fact that, yeah, we live together, but he looks after the child and blah, blah, blah. And therefore, you can apply based on the child because that's your child. And if if you are not in the UK to help look after the child, the child may not be able to ensure that their welfare is maintained because the child needs you around, be it mother or father. So we've looked at parent,
Yeah.
parent under two streams or gateways: biological parent that lives with the child and the other parent, or that lives away from or separate from the child and the other parent but looks after the child. So if you are looking after the child, we call it direct access. If you are living together as a family, we call it family unit. So direct access and family unit, where children are involved and you are applying as a parent, it's possible that you do not meet all the requirements. If you do not meet all the requirements, then your application will be assessed under EX1, paragraph EX1 of the Immigration Rules, Appendix FM, EX1, where you are living together as a family.
Mm-hmm.
The mother the father and the child living together, but the father or the mother who wants to make the application doesn't meet all the rules and the spouse, then the person can apply under Gen 3.2 of the immigration rules, paragraph Gen 3.2, because they don't meet all the rules, they live together, but they cannot apply as a spouse, and so they can only be assessed under child, because refusal will not be good for the child.
Yes, if you just joined us, the discussion going on is about the skilled worker visa and the options available to switch from one route to the other. Lawyer Chosasma is taking us through the family route, so to speak, where there are different options as well, either under the one that you apply as a parent of a qualifying child or as a spouse. And he's giving us the situation where even though you may want to apply as a parent, the qualification, the requirement will put you to apply as a spouse. And these are the bits that we have discussed so far. If you have any question, you can text it to 07399 208 468 or leave it in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. Well, let me run you quickly through the social media handles, and then when we come back, we will be going to the next strands of the options as Loyasma is taking us through. Remember, we're live on BWTV, and the program is The Community and the Law. This program is brought to you by BWF Solicitors. Yes, thank you and welcome back. We're still live on BWTV and bringing you The Community and the Law. Loyasma is with us and helping us through the various options we have as skilled workers to switch from one route to the other. Loyasma, yes, we have looked at the family route. Now, when we want to look at other options apart from the family route, what are some of the avenues open to us?
Thank you. So the next avenue is EU route.
Okay.
EU. With EU, somebody would have come to the UK.
Mhm.
They have parent in the UK from EU,
Okay.
or they may have even a grandparent from EU living in the UK.
Okay.
On that basis, the person will have to prove that they are applying to remain in the UK under EU rules on the basis of the relationship with that family member. But here, there are things we have to take note of. Point one, you are married
Okay.
or you are an adult.
It sounds like you are looking to secure your
You are an adult or you are married. In this case, are you living independent life? If you are not living independent life, do you depend on this family member, in other words, your parent or your grandparent? If you don't depend on your parent or grandparent, whilst in the UK or even before you came to the UK, then it is difficult. It will be difficult for you to show that you meet the requirement. Under paragraph EU 14. EU 14 is for 5-year or pre-settled status applications under Appendix EU.
Okay.
So you are a skilled worker. You are applying to remain in the UK with your mother or your mother's husband, or with your father or your father's wife. In other words, your step parent or your parent. So let's take example. John. John entered the UK as a skilled worker. John is seeking to switch because John's mother is in the UK from Italy and is resident with 5-year pre-settled status. So John is currently 30 years old. So John is no longer a child up to 21. John is a child of more than 21 years of age. John must then prove that one, he depends on the mother, because the mother is the EU person resident in the UK, and that the mother looks after him, and that even before he entered the UK, his mother was looking after him. That's dependency.
Okay.
Again, when John was coming, John filled an application form to enter the UK. John would have been asked, do you have any family member in the UK? Or do you know anybody in the UK apart from the employer you are going to work for? John would have said yes or no.
Okay.
If John is now saying that I have my mother in the UK from EU and I want to apply to remain, so I'm switching to EU visa, will it not be commonsensical to believe that John would have said yes when during the application stage he was asked, do you have a family member in the UK? True or false?
Okay. Yeah, you would have said that because that's the evidence for you to say, or that's the basis for you to say, I have somebody in the UK who is a EU national settled in the UK. Isn't it?
Yes, the point. But let's even assume that John did not contemplate switching when he was coming. He knew he was coming to work for his employer. 5 years, he will get indefinite. So his mother, yes, the mother is doing what she has to be doing for the child or the son.
Yes.
Sending him money, making phone calls, checking up on him, be a good man, be a good boy, be a good child, whatever. So the emotional support, psychological support, financial support, all that. Before John came, the mother was doing it. And when John came, the mother continues to do it. But when John was coming, he didn't even know that at a point he would switch. But if naturally it is true that John has a mother living in the UK, John wouldn't need science to say yes when they ask John, do you have anybody in the UK? John will say naturally, yes, I have somebody in the UK. And John will give the information about the person, mom, dad, whoever. But let's assume that John said no. Okay. And now John is going to make application based on the mother who never existed when John was coming. Would that be doubtful in the mind of the caseworker?
Yes, obviously the caseworker may be asking questions. Why didn't you tell us this? And now you are telling us. So if you're telling us this, then maybe moving the next step, ask that you give me evidence that such a person is the person taking care of you or your mother or your parent, isn't it?
Yeah, so the care bit may be there, but we are even establishing that is it possible on the balance of probabilities that this so-called EU mother is John's mother. Because if John's mother was living in the UK, John came to the UK 2023. John's mother was living in the UK from 2020. Okay. And still living in the UK. And now John wants to switch from skilled worker to the mother EU. But when John was coming, John couldn't remember that he had a mother living in the UK. And after 2 years, he remembers that he has a mother.
Yeah, has a mother.
Then this is where DNA becomes necessary. Let's assume that at the time of application, a lot was happening
in the mind of John, yes.
In his mind, and so he even forgot that his mother existed in UK. Granted that you made a genuine mistake. How do you then prove beyond that mistake that this is indeed your mother? A birth certificate will not be enough proof. Because there's already doubt created.
Okay.
And so to go beyond the doubt, you have to rebut the presumption that you don't have a mother. Because the presumption you created is that I don't have anybody in the UK. And so if there's anybody in the UK, the person would have come after John has arrived or after John's application.
Mm-hmm.
But John is saying that I had my mother who was in the UK before I even applied, but he didn't declare the mother's presence. So he's making an application. John would then have to include DNA evidence to support that even if I forgot to say so,
Mm-hmm.
the DNA is enough evidence that indeed this is my mom.
But then I remember on the same program you have made us know that it is unlawful or the caseworker cannot request for a DNA evidence. You would probably volunteer to give that so to make your evidence weightier, isn't it?
So that is why I said that this is where DNA becomes necessary.
Okay.
Because the DNA on this occasion
necessary but not a requirement.
Okay, but so the question is, we are rebutting a presumption.
Okay.
So if you are rebutting a presumption, the presumption John has created is that the mother didn't exist in the UK.
Right.
But all of a sudden, John is saying that my mother has been in the UK with 5 years pre-settled and is a EU national. So I want to switch to remain with my mom, EU.
Right.
That's not a problem. But we go to your history and realize that when you were coming, you couldn't remember that your mom was in the UK. And you said no. When we asked you, do you have a family in the UK?
You said no.
He said no. But all of a sudden, fine, you've remembered. That's why I said that maybe things were happening. It's that's a genuine mistake.
Mm-hmm.
But genuine mistake does not create a rebuttal of presumption that John has created.
Okay.
Because what John is saying that I don't have anybody. So if you have anybody, then beyond the birth certificate, you have to provide something. Because if you have your mom, so in this case, if John said yes, and John is now making an application based on the mom, then it's so easy. Because John has already declared that he has a mom.
Okay.
So then it follows on from what John has already said. And therefore, somebody makes an application based on a grandparent or a parent, EU, in the UK. They will go back to the person's application to check whether they hinted that such a person would have been in the UK. Not the name of the person, but the fact that you have a family member.
Right.
Right. So that's something I want to point out, because people may be saying that, oh, lawyer, I made an application and they refused because they said they don't believe that I have a family member, because when I was coming from abroad before, I didn't declare on my application that I have a family when they asked me about if I knew or I had anybody in the UK.
Right.
That is where DNA becomes necessary. Even though it's not compulsory, it is necessary for you to rebut a negative presumption.
Okay. All right. So yeah, we have looked at the EU route. Let's, for the sake of time, let's look at any other option that we could have. I remember in your introduction, you mentioned that we could switch to a different work strand or whatever it is. Can you expatiate on that for us, please?
So the work areas, you came as a carer. You can switch to other categories, nursing, auxiliary nursing, or any other construction, or any other that is permitted. In other words, you have to meet the requirement under that new category.
Okay.
And because your visa hasn't expired, you can do so.
Okay.
Right.
Now,
so that's the update.
Let's assume that I entered as a care worker in the health sector, and I want to switch to a different category, probably a higher grade, say nursing or whatever it is. That is allowed within that.
So that is the work transition category. So you can transfer within the work spectrum.
Okay.
Work, because all these are work, different categories of work. Okay. So you can transfer from one work to another, or you can transfer within the same work but different employer.
Okay. So I have ABC care and I have XYZ care. Then I move from ABC care to XYZ.
So
Same.
that would be good. That would be horizontal transfer.
Okay. And I can upgrade myself to higher grade with
You can also downgrade depending. So you can even then move to auxiliary nurse 6131. So then that will be vertical transfer because auxiliary nurse, even though it's still care, it's not part of the 6135 and 6146 and 6136. So changing employer, the same job category, changing employer is vertical transfer.
Okay.
But if you are changing from the same work industry, if I say work industry, the same work, but different industry, different employer, then that's vertical transfer or vertical switch. These are my interpretation. This is not within the rules. This
So
is
you
how
can switch vertically or even horizontally.
exactly. Horizontal means that the same care, but to different employer care. So care, different employer. But you are changing from care to construction, changing from care to nurse, changing from nurse to teaching, changing from nurse to IT, different industry, different employer. I call it vertical transfer.
And is that possible? And
Yeah, if you meet the rules.
If you say meet the rules, for instance, I'm changing from healthcare to construction, for instance, then I would have to look at what the criteria and the requirements are for the construction industry.
Exactly.
And if I meet them, I can move.
Exactly.
Provided my visa has not expired.
Exactly. Yes.
Okay.
Yes.
All right.
Right. So that is the work transfer, vertical or horizontal transfer. But you can also decide to forget about work and go into different area altogether. And
Like,
different area altogether will be where you say, you know what, I don't care about job again. I now want to go into my family and I'm applying as a parent.
okay.
I now want to go into my family. I'm applying as a spouse because I have found love and I'm in love and I'm married. So spouse. Or, you know what, my EU mom, my EU dad, my EU grandpa, my EU grandma, my EU whatever has been in the UK. I've now remembered that they could have done it for me. Then I'm moving to their side.
How easy are these done?
Well, easiness is in the requirement.
Okay.
Whether you will succeed or not, it's a matter of evidential computation.
Okay.
The rules are clear. For example, let's say you are applying as a parent.
Okay.
Now, you came with your spouse, skilled worker spouse.
Mm-hmm.
You came in 2023. 2025, something happened.
Yeah.
You moved on with another woman, cheating on the other one. The other one finds out. The other one says, I don't love you again. Then you say, if you don't love me again, it's opportunity to continue my escapade. And so I'm now going to marry this one. If married this one, your visa is still valid. This one will tell the government that, you know what, the relationship is no more. And they give you 60 days. Within the 60 days, you switch to be with your new lover who qualifies to sponsor you. Then that is a fair switch.
Okay.
So that's spousal switch. Switching from skilled worker dependent to appendix FM sponsor. But then you have to meet the requirements.
That would go under either the 5-year route or the 10-year route, depending.
In this case, because it's a spouse can only be under 5-year route. So you have your immigration visa, which is yet to expire because 60 days is not yet due. Mm-hmm. Or you have even 1 year left, it's not yet due. So your visa is still valid, immigration status met. You have been working and you are earning 30,000. So you meet the 29,000 threshold. Mm-hmm. Your employer, your sponsor can also add his or hers. Then you move on to relationship. You have evidence of marriage. Mm-hmm. But you must also show that before you married this new one, you had divorced the first one. So you have to add divorce. Then you move on to show accommodation. Accommodation, it doesn't matter. All you need is one bed for you and your partner. So if your partner is living in somebody's corner, that is enough accommodation because you share one bed. Mm-hmm. So you've met the accommodation threshold. But because it's spousal, you have to write the English language um, exams for A2. Then you switch to Appendix FM spouse visa and you do away with skilled worker brouhaha.
Okay. All right. Well, folks, if you have questions, obviously, about so many of them, Lasma is still here and he's ready to answer the questions that you have. He's opened up the discussion, and I know you may have your peculiar situation that you want to get him clarified for you or throw more light on for you. The lines are active 0208 493 7345, or you can send a text, WhatsApp message, or a voice note to 07399 208468, or you can leave your questions and comments in the comment section down below on Facebook and YouTube at BWF Solicitors and at BWTV UK. Remember, I asked this question based on the nugget I gave you earlier on, and I said that, quoting from Section 13, 1A and 1B, Employment Rights Act of 1996, it is unlawful for an employer to make a deduction from wages of a worker employed by him unless the deduction is required or authorized to be made by virtue of a statutory provision or a relevant provision of the worker's contract. Or the other situation would be where the worker has previously signified in writing his agreement or consent to the making of the said deduction. Then I gave you the scenario of my dear friend who was employed in Care and Cure Limited. After all deductions, Philippa was receiving £2,000 per calendar month. The deduction included her income tax, national insurance, and pensions. Now, last month, that is December 2025, she received her money less £150, and the employer said, no, you didn't come to work one day, and we decided to ask somebody to cover your role, and that is what we used to pay for that. So Philippa is asking, well, I don't understand. Can you advise me? So you and I, having heard the nugget, having heard the explanation, we're going to ask Philippa to ignore it because he was absent. The 150 was used to pay for her cover. Or I'm going to say, no, it wasn't agreed. So the employer is supposed to give that back to her because that was unlawful. And or you can say none of the above because the deduction was a mistake. And definitely it would reflect in her January 2026 salary. 0208 493 7345. That's the number. After these, reminder of our social media handles. We'll go to the lines and also your questions. Yes, interactive time. So 0208 493 7345. Comment section down below. Send your text 07399208468, or you leave them in the comment section, as I said. We have somebody on the line already. Hello.
Hello.
Yes, good afternoon.
Good afternoon, sir.
Yeah, Charles, can you hear our friend?
Yes, I can.
Okay, good. And my dear friend, can you hear Charles as well?
Yes, please.
Fantastic. Please go ahead with your question.
My question is, I'm a skilled worker, and when my visa was about to expire, my company intend to do the extension for me.
Mhm.
They tried the extension through the company's lawyer, and the Home Office rejected the application with the reason that if the company fails to provide a sponsorship certificate, because the company is being under investigated. So that's the reason why they rejected the plea. So I contacted the lawyer and said I shouldn't worry. It's going for judicial review and everything will be okay. But now I can't access my share code. Everything has been down, and I don't know if I'm at the fault or the company is at the fault now.
Charles.
Right. Director, how are you?
I'm doing well.
Good. So you say that application was made for your renewal, right?
Yes, please.
And as far as you were told, they added the sponsorship, the new sponsorship certificate.
Yes, please.
And the Home Office said that, or the caseworker said that it wasn't valid or it wasn't added. Which is which?
I think they couldn't. The one he forwarded the message to me with the reason that they requested for a sponsorship certificate within 14 days, but I think the lawyer didn't provide it, and they rejected the application.
So the reason is that they asked for it under evidential flexibility and it wasn't provided.
Yes, please.
Is the lawyer saying he provided?
No, he said, I think the company being investigated is an investigation. That's why they don't have the certificate of sponsorship.
So the company was under investigation, and so there was no sponsorship certificate added to your application.
Yes, please.
So it is true that you applied without new sponsorship certificate.
Yes, please.
Right. And it is true that when they asked for it, you couldn't provide before they made a decision.
Yes, please.
And you are still saying that you don't agree why you have been refused.
Yeah, I'm just asking, is it my fault or the company's fault? Because the company
it is nobody. The question
because the company is very good. I didn't want to be ungrateful to them, and I had a chance to switch to a different company, but they said they are going to do it for me.
Yeah, because we are discussing law, we are putting away emotions. Okay.
Yeah.
That's why we are not saying it is your fault or the company's fault. That is emotional consideration. We are talking about pure objectivity, law. The law is that when you apply to renew, you must show that you have been given a new sponsorship because the first one was over, right?
Yes, please, over.
Yeah, so you were renewing and you had to go with a new one. Fine, sometimes we forget. So you put in, you forgot, and they came back to remind you, and you still forgot to give them. And they made a decision to refuse you. So if they have refused you, then that's a genuine refusal because you didn't meet the rules under the relevant provisions of the skilled worker provision or appendix. So if you are saying you are going, for example, to challenge the decision under administrative review and later judicial review, you are going to fight a losing battle because you don't qualify. Because that means they made a genuine decision to refuse because you didn't meet the rules. If they said that they sent everything and the caseworker is saying they didn't get it, then we can look at when you sent and when the decision came. And if there's evidence that it was sent to them, then we will blame them for not having it to rely on. But you didn't give it to them, and they made the decision without the requirements. So that means you didn't meet the requirement, and so it's a genuine refusal. Can you challenge it? No. You cannot fight a battle that is genuine.
But lawyer, you mentioned that we're talking law, so emotions aside. But this is a situation where he kind of was given an assurance that we're going to renew for you. Can't we do anything about it, emotion-wise?
Yeah, I understand. In this case, it's still law. In this case, it's not a question of are they right or wrong. The question will be who
should provide a remedy?
Who's to blame? Who is to blame? The company said they will let you apply. The company applied for you, and the company didn't do the right thing. But if you are going to blame the company, you still have no visa anyway. We are talking about visa at this stage. So unfortunately, the Home Office cannot be blamed. But the employer, what will you do about if you are blaming the employer? You can only take the employer on under contractual obligation or breach on the basis that there was a contract between you per the conversation that went on for the employer to apply on your behalf. And the employer, through their lawyers, made a mistake. And so they have to fix you up. But how are they going to fix you up within the same visa? No. Then they have to compensate you. But that's a different conversation that you can take the employer on and on that basis. But we are talking about whether this refusal can be fixed. No, it cannot be fixed because the person has been refused. Even if the person is going to challenge it under administrative review, what will be their basis for challenging it? Are they going to say that my employer said they have it and that it's there? But yes, your employer said, but it's your application. So if you have a business, deal with the employer. You see? So, unfortunately, on this particular question, the answer is there's nothing he can do. It's a genuine refusal. There's no remedy here. The only remedy possibly would have been admin review, but it's not possible to fight because you don't meet the rules. Indeed. And again, you can't go for a judicial review because the court will just throw the matter away and say that, hang on, if you didn't meet the rules, why are you coming to me for me to intervene?
Okay. You, there may be options. So if you could speak to your lawyer again, or if you would prefer,
So
you can.
Black could ask him for me when he spoke to the lawyer. What did the lawyer say they would do next?
It's good for a review. That's why you told us you shouldn't worry about it.
Well, what I will tell you is that review will not work. The lawyer is just telling you something so that you have a feeling that something is happening. But don't be in a fool's paradise. The objective position is that there's nothing that was done right by the employer, and so the visa has been refused genuinely. Whatever they are going to do is just to water things down for you. But be real with yourself and know that it's never going to give you a visa. And so if you've got something to do it immediately. So ask them, you didn't send a certificate of sponsorship. So on what basis are you going to fight this? Ask them and come and tell me what they told you.
Okay. Speak to them, and if anything, let's speak again. Okay.
Okay. Thank you very much.
Thank you very much. There, somebody is going against my rule, but I will allow it. Hello. Can you hold on? I'm calling you on the landline because this is not clear at all. It's not clear. So either call back on the studio line or wait, and I'll call you back after the score. Okay.
Okay, no, that's fine.
Okay. All right. Thank you very much. Hello.
Good evening.
Good evening.
Please, my name is Caroline, speaking from Leighton.
Caroline, yeah, thank you for joining us and thank you for coming up. Yeah, lawyer can hear you, so please go ahead.
Thank you so much. Please, so I came as a care worker.
Last one, please, can you hear our dear lady?
Yes, please, I can.
Okay, good. Go on, my dear.
Thank you so much. So I came as a care worker with my 3 children. So the last one of 3 when I came. So my husband is a teacher, and then we switched to family roots. But I don't know if I can say fortunately or unfortunately, I got pregnant because I was taking care of the 3 because he couldn't get enough, he couldn't get school. Can you hear me?
Yeah, we can hear you. Go on.
Okay, thank you so much. So now I got 2.5 visa, which is almost, but before I realized that I got pregnant again. So it's like I have 1.5 and then 5 months. And so for that month, I didn't even start any week. I'm home. So my visa went through, the family route went through, but the 3 children, it's about more than a year now that we put, he wanted to switch their, since I came and they were dependent on my visa. He did only mine, and as for them, he did it last year, but almost like a year now. They feel good because they say I didn't add my bank details. So we reapplied about 2 months ago, but we haven't received any information from them yet. And it's like a few months to go that their visa will expire. So I wanted to know if their visa expired and then we have not heard from the home office, are they going to be deported or what? And then another one is since I haven't started any work, I have 5 months baby now. I'm seeking for a job, but if I could not get any job, if I apply for waiver, will it be acceptable? Was there any chance for me to apply for waiver because my husband also has lost his job as a teacher?
And let me just add this and ask. Maybe the lawyer may have asked, but let me. You came in as a skilled worker, right?
Yes, sir.
And now you are looking for a fee waiver because at the moment you are not working, and for any application you do, you may not be able to afford it. Is that what you are saying?
Yes.
Okay, Uncle Charles.
Yeah, Madam, how are you? Is it Caroline?
I'm fine, sir. Thank you.
Yes, good. When does your visa expire at the moment?
Come again, please.
When
Your visa expire?
does the visa expire?
Okay, so the 2.5 I got it to end at June. Yeah.
June 2020.
26 this year.
So you are asking if you can get a fee waiver to renew once it's about to expire.
Yes, if I can apply for waiver.
Yeah, that's the question. The same question you are asking is what I have asked. You want to know if you can get a fee waiver to apply for your renewal.
And please, I didn't get this one.
You are asking, that's the question I asked you. Are you asking if you can apply for a fee waiver?
Yes, sir.
Okay.
And
Okay.
my children own too.
We'll come to your children. So I'm taking the second one.
Let's handle yours. Let's handle yours first.
So yes, you can apply for a fee waiver, but you have to prove that you cannot afford. You said.
Hold on. Lawyer, just take your time and listen. Okay. He is answering your question, so just take your time and listen. He says that you can apply for a fee waiver, but you have to prove that you can't afford it. Okay?
Yeah.
Okay, lawyer, let's continue.
So, are you doing it yourself or your lawyer will be helping you?
Please, I'm sorry, I can't get the lawyer's question very clear.
Are you doing the fee waiver application yourself or you have a lawyer to support you?
Oh, okay, so I have a lawyer to support me, but I just...
Good. No, that's okay. Don't worry. Don't add but. So because you have a lawyer to support you, the lawyer will guide you through what evidence you need, the bank statements, the support from people, all those things to prove that your income from work and your income from other people all together is not enough to meet your expenses and that of your children. And so you need to be given a waiver to pay for the home office fee for the renewal application. Okay?
Uncle Kwasi, please, if you can help me, I didn't get it. So if you can
what the lawyer is saying is that once you have somebody or you have a lawyer helping you, they will guide you through the evidences that you need to prove that you cannot afford the fee. Okay? And when that is done and is acceptable, they will grant you the fee.
Okay, so I'm not working now. I've never worked since I came here, and
So the lawyer will ask for all the evidences that shows. They will ask how much you spend, how much you receive, which you are saying that you don't receive anything. All these will be put together to make a case for them to waive the fee for you.
I'm still under no recourse for public fund because I've not yet received my settlement. I am under 2.5.
Yeah.
Can it still be
Lawyer,
possible?
I think the conundrum here is she has no recourse to public funds on her status at the moment.
No recourse to public fund is that she cannot take benefit. But when applying for a fee waiver, and because the application is human right, she qualifies under Section 6 of the Human Rights Act to request a waiver of the fee. So it has nothing to do with her benefit status.
You got that, didn't you?
Yes, I got that one. Thank you. And what about my children, please?
Now, your children, let me get it right. You said that when you were making certain transitions, you didn't add the children. Yeah?
When I was coming here, I added them. But when my husband was, when we were doing the family group, I thought, well, I mentioned everything.
Okay, all right. Don't worry. Let me ask this question. Your children application is pending. On what basis did you apply for your children? Was it based on your child?
I didn't get it, please.
On what basis did you make an application for your children?
When I was coming here.
So when you were coming as a skilled worker, you added your children to your application to say that you have children?
Yes.
Where are the children? Where are the children now?
They are here with me.
Yes, and you have made an application for 2.5 for the children, right?
No. Well, I didn't even know anything about what my husband was doing with the lawyer.
No, don't worry. Don't worry, Caroline, don't worry. I want to understand who made the application for the children.
My husband.
Your husband. On what basis did your husband make the application? Do you know?
Well, I didn't know, but when I asked the lawyer, he said on family roots. That's what I told you.
So you know. So it's family root, you know.
Okay,
Are you with me?
yes.
So you applied under family root. That means your children's application might have been made under the British child. That is their sibling. They have a sibling that is British, right?
Yeah, they have children that is British, yeah.
They don't have children. They have a sibling.
They have siblings, yes, sorry.
Yeah. So the siblings that are British, you applied based on those ones. Now, so you have a child that is British. They have a brother or sister that is British. So that your husband might have applied for them on the basis that they have a family member who is British, and that is their brother or sister. So if they are taken away from the UK, their brother or sister will be crying, and that is no good for children to grow up together. So that is the argument they might have put forward. Whether they will grant or not is a different matter. Your worry is that it's been how long? 5 months or 2 months?
How long has it been?
About 2 months now. But
Is that your worry?
Last year, about September, and they refused it because they said I did not add my statement, my bank statement, and we did it about 2 months ago.
Caroline.
Again.
Caroline, we are not worried about what happened 2 years ago. We are interested in now. The one you have submitted. How many months ago?
This one was 2 months ago.
2 months, and your worry is that it's taking too long. Is that the case? What's your concern?
Yes, it's taking too long, and in case they've been refused, are they going to be deported, or is it because?
Oh, okay, all right, I get it. So I don't know whether they will be refused or not. I haven't seen the application, and I don't know whether they met the requirement. But what you are saying is that 2 months, is it too long? No, it can take 1 year. So just relax, okay? Two months is just too early to worry.
Yeah,
so give yourself.
Come again? An application and it's with them, so don't worry.
Okay, so it's not really application, man. I said he has lost his job, so he's seeking for free waiver for the children before even the application.
Oh, so your husband or yourself, neither of you have put an application for your children yet? Is that what you're saying?
No, okay.
The application is hold on. Take your time.
Sorry.
The application for your children is with the Home Office at the moment. But you are saying that any further application you're going to make, either for yourself or your husband, you don't have the money to pay. So you want to apply for a fee waiver, correct?
That is for me. As for him, he settled.
Fine. So for you, you have a difficulty in paying, so you want to make a fee waiver application, correct?
Yes, please.
Don't worry, let your lawyer help you, okay?
Please, I'm sorry about my concern.
No, okay. So, Braco,
I'm not should even have a problem. Because the
Braco,
application is with the Home Office.
Braco,
We haven't
Yes,
even
hold on,
started the
hold on.
application. We are asking for fee waiver.
Hold on. Lawyer is talking, so hold on.
Braco, okay, Jocelyn.
Is it
Hello,
Caroline?
sister. Oh, sorry, Sister Caroline. Sorry, Sister Caroline.
Yes, sir.
Okay, your children's application is with the Home Office. They will make a decision and they will tell you later. It may take some time. It can take 6 months, 9 months, or 1 year, but it will come eventually. It will take time. The question is, when they are refused, would they be deported? No, they will not be deported. Even if they want to deport them, you can challenge in court. But because their father has indefinite, because that is something we didn't know. Their father has indefinite. That's why he applied for them, maybe. So not based on maybe the siblings, but based on the father himself. So let's wait. So let me ask you. So you see, all you have to do now is just focus on yours. Give yourself time about the children's application that is pending, and focus on your application fee waiver. Okay, spend the time, the energy, and all your strength to work on yours. Don't think too much about the children. It will take some time, so work on yours. Would they be deported? They won't be deported easily. Okay.
Okay, so please, for the last one, I called and then I talked to Auntie Eunice. I called the firm the other time, and I wanted to know. I didn't ask her the other time, but I'm asking if I can switch. I can now start review if I want to. Is it possible to like switch lawyers?
Switch to what?
Is it possible? If I want to change lawyer, if
Of
I
course.
want,
You can transfer. Yes, you can transfer your case to us. You can, of course.
I can't.
You can. You can. It is
Okay, thank
possible.
you so much.
You can bring it to us if you wish.
Okay, thank you so much.
Okay, all right, thank you. I know definitely you also have your concern. You can send them to the comment section. Producer, let's pick up some of the questions or the comments from the comment section, and then we'll come back to do the other bit. I'm on Basteya with medical conditions, hepatitis B. My GP has now referred me to a specialist clinic, which I'm booked for next year, June. Is it possible to make an application based on that? Lawyer.
So this person is asking whether hepatitis B is enough to apply under paragraph PL 5.1B of Appendix Private Life, because this is an overstayer with less than 20 years. They didn't say how long, but I want to believe that they've been in the UK for less than 20 years. So they don't qualify under 5.1A. Question is, can they qualify under 5.1B using hepatitis B as a reason why they can't survive in Ghana or in their country? I don't know where this person comes from, but they will look at the country profile, whether hepatitis B can be treated in that country. If hepatitis B can be treated in that country, then it wouldn't be strong enough reason why you cannot go to your country. And it's likely the decision to grant will be no. They may refuse the application. So if it is private life, then it is not likely to succeed. If it is based on your children, be it your own child or stepchild, then that is likely to succeed. So I don't know how you want to apply, but I've given you all the options. You cannot apply based on your wife alone because you don't have a visa. You cannot apply based on private life because hepatitis B is not a good reason why you cannot be relocated to your country. It is treatable in your country, I'm sure. That's what they will say. And therefore, your only option will be as a parent, biological parent, or as a parent, step parent, where you are married to a woman and the woman has a child who is British or has indefinite, and you are applying as a stepfather. or step parent.
Okay. All right. So let's pick up another one. See what there is. Greetings, Honorable Zafisha Poe. Can I combine income from my two jobs to meet the financial requirement for my visa renewal? My primary sponsor's hours can fluctuate due to client circumstances, but my second job provides stable and consistent income. Lawyer.
Yes, a Trevor can combine two jobs income.
Okay. Right. Ochefor, thank you very much. Let's see what else we have on the platform. In the comment section down below on Facebook, Rose is saying you have provided a clear and comprehensive overview of the available options for switching to alternative visa routes, presented in a way that is both accessible and informative. Thank you so much, Council. Charles Asma. Thank you, lawyer. Thank you, my dear. Do you help to get to apply from the Home Office as limited company looking to hire from abroad? I don't know what Patrick wants to say. I don't know whether you can
Yeah. That's a sponsorship license. Yes, sponsorship license. Patrick, book appointment for sponsorship license advice. Then we take it from there.
Okay. All right. Patrick, thank you very much. Do that. Let's go to the lines. Hello.
Yeah, hello.
Yes, good afternoon.
Hi, yeah, good afternoon.
Yes, thank you for sticking. I know you've been trying to reach us, and we have to take care of everybody else as well. Lies on the line. What's your question, please?
Okay, hi. My name is Godfrey. Yeah. So basically, I came to this country on a spouse visa and a skilled worker visa as a dependent. Yeah, and somewhere in 2023. And then as I stand down, it looks like my being applicant actually, as usual, I hope you know what is going on in this country, trying to do one or two things. However, my company that I'm working with at the moment, it's a clear that like I'm working with at the moment, and they've got a sponsor license whereby they are going to sponsor me, but I don't have an outlet, neither a degree or or whatever, and they are willing to sponsor me. And my question is, can dependents switch at the moment? Because I know that the rule is that if a dependent no more switch and stuff, and a lot of people saying different things and stuff. So my question is that is there a possibility whereby as a dependent can switch to the company that I'm working with at the moment?
Okay, so you're working with them as dependent, but now you want to apply for your own license so you stand on your own and not depend on it.
Not exactly on my main applicant.
Okay.
And they are willing to do that, but I don't have the English.
Hold on and let lawyer help you with an answer. Yes, Uncle Charles.
Sure. Director, I just say. Good. I'm going to switch to English. So my understanding is that you are a dependent of a skilled worker. You have opportunities to switch, but due to the requirement, you want to ask if your spouse can switch and you continue as dependent. Excuse me. Is that a question?
No, it's not a question. I'm a dependent on my main applicant, yeah. And now as it stands now, she is doing one or two things today, tomorrow, that.
It's the same thing, my brother. That's the same thing. The same thing. Sorry. The same thing is what I repeated. You have opportunity, but because of the English, you want to swap with the lady, right?
Yeah.
Yeah, so that the lady can go in and you remain as dependent. Is that not a question?
No, it's not a question. So that I want to be excluded. I mean, I don't want to be more like I don't want to be on under. I mean, like I don't know how to explain, but understand. Like,
so you want to be on your own, not
my own,
not depending on any other person, because you don't trust your main dependent now. Is that what you're saying?
Now, today that, tomorrow that. Then there was a time that she even made a comment that
even if I go to Ghana, she might be putting something there. Then I'm
All right.
So you would want to find out how you can meet the requirements so you can stand on your own.
And is it possible for me to switch to become a main applicant?
Lawyer.
Yeah, so your question is you want to become the main applicant and you've got a job offer, but you can't meet the English requirement, right?
They do have the sponsor and then they've got a COS that they are willing to sponsor me, and I'm a dependent.
No, what you're saying is you have a challenge in passing the English language or meeting that requirement. Correct?
I think, it's not like I'm having a challenge in regards to English requirement. My question is.
Oh, okay. You want a yes? Hold on. You want a yes or no? Whether you can switch from being a dependent to a main applicant.
To main applicant with the company that I'm working with.
Yes, because the company is prepared to sponsor. So if it is possible, then you have to meet the requirements so that they can make that application for you. And you want to find out if it is possible.
Yeah, but I don't have degree and I don't have IELTS.
But is the company requiring that you bring IELTS or whatever? What are the requirements from the company?
No, they haven't asked me anything yet, but I don't know whether if I have to do it or not.
Hold on.
All right. Let's answer him.
The job category you are in has its own special code. Okay?
Yeah.
They are happy to sponsor because they're happy to work with you.
Yes.
What I would advise is find out what their requirements are, speak to a lawyer, and let them help you go through that so you can become your own person. Okay? Because it's possible. Is that okay?
Let's add to it.
Hold on. Lawyer wants to add something else. So listen.
Okay.
Yes, lawyer.
Yeah. Director, I want yes or no from you at this stage, okay? I will ask you a specific question, yes or no only. You've got a job offer, yes or no?
Yeah, I've got a job offer, and I've been working with it for like almost
yes or no, yes or no only, yes or no only. You've got a job offer, yes or no?
Yes.
Now, these people are going to sponsor you so that you become independent, yes or no?
Yes.
You cannot write the English if there is English, yes or no?
I can, but I just want to know if I can switch.
So you can. So you can write the English, right?
Yes.
What job is it, please?
It's supported living.
What? What, please?
Is that supported living?
Yes,
supported living.
Like a care home.
Is it care?
Care. Yeah.
Okay, I don't know what the code is because there are some. How long have you worked with this employer?
Close to 2 years now.
2 years now, right?
Yeah.
So speak to the employer. What do I need for me to be sponsored? English, obviously, you need that, but there are specific requirements in terms because you are now going to transfer from being a dependent to a main skilled worker. And there have been changes in the rules from July 2025. So speak to your employer that based on my circumstance, what do I need? And they will work with you. If you need a lawyer, you can get a lawyer to work with you on the application side of things. Okay? But if you meet the requirements, then of course you can switch to become a main applicant.
Okay, so my other question, sorry. So if I become a main applicant, and now I think I've got 2 years to for my independence with me. So am I going to start afresh or it will be continuing?
Okay. So the one you had was as a dependent, right?
Yes, please.
And you have decided to abandon that and start life again as independent, right?
Yes.
So your life will start as independent.
Wow.
It's better than
My answer
nothing,
has
my friend.
Yeah, my question has been answered. Yeah. So
Okay. All right. Well, thank you very
thank you.
much. Well, unfortunately, we ran out of time. So thank you for coming, and we hope to have you again another time when we have the program. We'll be back next week. Okay.
All right. Then. Thank you so much.
Thank you. All right. We've gone past our welcome, but let's see what it is that we have. So, yes, let's see my question. The answers you gave me. I gave you that scenario based on a nugget. Philippa, who works as a healthcare assistant at Care and Cure Limited, salary 2,000 per calendar month after deductions. Deductions included income tax, national insurance, and pensions. In December, she wasn't given 2,000, but 1,850, and the reason was that uh, she was away 10 days unauthorized, and that 150 was used to pay for the person who covered her duties. What advice would you give? We've given you three scenarios. Daniel Adikafi says number two, as Philippa has not agreed to the deduction with the employer, it is unlawful for the employer to do so. Pauline Sue also thinks it's number two as well. Thank you. Kwekuba 4 thinks it's number three, none of the above, because the deduction was a mistake and a refund will reflect in Philippa's January 26 salary. Elizabeth Asari says it's number two. Thank you, Lizzie. Next one, Ohima Jemfi, as Philippa was absent without permission from work, the 150 deduction is fair to pay for the cost of her cover. Peggy also thinks that is fair. We go to the next one. Kwabra Jemfi says, no, it's not fair. She has not agreed to the deduction, so it's unlawful for the employer to do so. Elizabeth Jedu says none of the above because the deduction was a mistake. Jacob Abaji thinks it's number two, very unfair and unlawful for the employer to do so. Michelle Odro says number two is unlawful for the employer to do so. And we have the next one, Mami Grace also says it's unlawful for the employer to do so. And what's my answer? I will ask Leah. Leah, what would be the correct one?
I was gonna say that. What will my students say? Right, it's good. It's good. It's early in the year, right?
Anyway, yes.
Yeah. So come again.
As for this one, spare me.
I understand. Yeah. Yeah. So well done to all those who attempted. Now we look at which of the answers sit well with the law. So we look at section 13, subsection 1, subsection A and B of the Employment Rights Act says that any deduction that is not by law, any deduction that is not agreed to by the employee and is done by the employer unilaterally or independently will be unlawful. And so this is somebody who has worked, the person went on leave unauthorized, then the employer says that we have hired somebody to cover you, so you will pay the person. That would be too harsh on this individual, because if the person has been away and you are not happy, sit the person down, check your disciplinary procedure for absence, and deal with the person, and do what we call return to work interview with the person. But you cannot take money from the person's salary because they've been away without telling you. It's your business and you need a cover for your business. But asking the person to pay is wrong and against the law. And that the answer is 2.
Well, the answer is 2 is unlawful for an employer to deduct employees' wages without consent or statutory or contractual backing. Therefore, Philippa must challenge the lawful basis of the £150 deducted from her wages. And what I said is based on Section 13(1) of the Employers Act or Employer Rights Act of 1996. So, yeah, you err on the caution of the right-hand side of the law. Well, this afternoon we have looked at the very interesting topic of skilled worker visa options for us, or options available to us to switch to different routes. Lawyer, please sum it up for us.
Thank you very much. So, viewers and listeners, today we have understood that as a skilled worker, you have options to switch. One, you can switch within the skilled work category where you can change employer, the same industry, or employer, different industry if you meet the requirements. But do so before your visa expires. You can also switch completely to a different area, for example, family, where you have family in the UK. Family in the UK, as a parent, you have children who qualify because the children are British, or the children have indefinite leave to remain, or the children have EU passport with 5 years, or EU passport with indefinite, that's settled status, or the child or children born in the UK, lived in the UK for 5 years, or child or children born outside the UK, brought to the UK, lived continuously in the UK for 7 years. The law says that these are qualifying children. Therefore, you can apply to remain in the UK based on your qualifying children as a biological parent. You can also apply as a step parent if you are married to the mother or father of any of such children. If you are applying as a parent and you don't live with the other parent of the child, then you must show that you have a role to play in the upbringing of the child. You can also apply as a spouse if you are married to someone who has indefinite leave to remain, or has British citizenship, or has 5 years under EU but EU passport, or indefinite under EU with EU passport. The law says that these are qualifying partners. So based on your qualifying partner, you can switch from skilled work visa to a spouse visa under Appendix FM as well. You must prove that your relationship is genuine and subsisting. You must meet all the requirements, including 29,000 threshold. If you are living with the mother and the child, or the father and the child, and you don't meet the requirement for income and English, you'll be put under 10-year route. If you meet the requirement under English and finance, and you live elsewhere and the child lives with the other parent, but you play a role, you can be put under the 5-year route. So these are the options you have. Your last option would be under EU, where you are applying to remain or switch to EU family member visa category based on your mother, who is an EU national with stay in the UK, or father, who is an EU national with stay in the UK, or grandparents who are EU nationals with stay in the UK. These are all options that you can explore. In any of these, you must make sure that your visa has not expired before you take that step. You must meet the requirements. In case of support, get in touch and we'll be able to take you through further.
Thank you, and thank you so very much for your time and, of course, the share of knowledge this afternoon. Those of you who were able to get through, thank you, and we appreciate that. Those who could not, time and tide, they say waits for no man. Unfortunately, we're not able to pick that. But we will be back again same time next week. If you have any further questions, you can send them to the platform or send them to BWF Solicitors, and we will endeavor to get them answered for you. It's been lovely, and the year has started on this very high note, and we believe we'll be moving on like that throughout the year until it ends. And I've told you that along the line, we invite a handful of you to visit us in the studio. You have that direct interactions with the lawyers, and you can pose the questions yourselves. Uncle Charles, thank you. And thank you to BWF Solicitors from the very top to the very last person, which is me. And to my production team made up of my producer, Professor Ade, Sheila, and Cran Padmo Dudu. Stay together. Thank you once again. And we hope to meet you again same time next week. Until then, please be good.